Third, on the application of the appellant under section 256 within bracket 1 of the Act, the aforementioned questions were referred to the High Court of Kerala. At Ernakulam, Mr. Roy Abraham, learned counsel for the appellant, urged the very same two contentions which were argued before the High Court, namely, para, within bracket 1, that the exercise of jurisdiction by the Commissioner under section 263 within bracket 1 of the Act was not only unwarranted but also illegal. He contended that mere loss of tax could not be treated as prejudicial to the interests of the revenue, and that only when the order of the assessing officer would affect the administration of the revenue, that it would be treated as prejudicial to the revenue. Within bracket small I, that the amount of rupees 3,66,649 was in reality agricultural income and therefore ought not to have been brought to tax. Mr. Anup G. Chaudhuri, learned senior counsel for the respondent, asserted that the income tax officer passed the order without the application of mind, and in as much as it resulted in loss of tax, it was also prejudicial to the interests of the revenue. Therefore, the exercise of jurisdiction under section 263 within bracket 1 of the Act by the Commissioner was justified and legal. He further submitted that the second contention was not open to the appellant, as the basic facts found the appellate tribunal were not questioned before the High Court to consider the first contention. It will be apt to quote section 263 within bracket 1, which is relevant for our purpose. 263. Revision of orders prejudicial to revenue within bracket 1. The Commissioner may call for and examine the record of any proceeding under this Act, and if he considers that any order passed therein by the assessing officer is erroneous insofar as it is prejudicial to the interests of the revenue, he may, after giving the assessee an opportunity of being heard and after making or causing to be made such inquiry as he deems necessary, pass such order thereon as the circumstances of the case justify, including an order enhancing or modifying the assessment or cancelling the assessment and directing a fresh assessment. Stop para. The High Court held in this context it must be regarded as involving a conception of acts or orders which are subversive of the administration of revenue. There must be some grievous error in the order passed by the income tax officer which might set a bad trend or pattern for similar assessments which on a broad reckoning the Commissioner might think to be prejudicial to the interests of revenue administration. In our view, this interpretation is too narrow to merit acceptance. The scheme of the Act is to levy and collect tax in accordance with the provisions of the Act, and this tax is entrusted to the revenue. If due to an erroneous order of the income tax officer, the revenue is losing tax lawfully payable by a person, it will certainly be prejudicial to the interest of the revenue. The phrase prejudicial to the interest of the revenue has to be read in conjunction with an erroneous order passed by the assessing officer. Every loss of revenue as a consequence of an order of assessing officer cannot be treated as prejudicial to the interest of the revenue. For example, when an income tax officer adopted one of the courses permissible in law and it has resulted in loss of revenue, or where two views are possible and the income tax officer has taken one view with which the commissioner does not agree, it cannot be treated as an erroneous order prejudicial to the interest of the revenue unless the view taken by the income tax officer is unsustainable in law. Stop. Thank you. শুরু করলাম।